enroll in our program by forms that are provided with all the district attorney's offices. We have an online form, and sometimes folks just call in and we enroll them over the phone. So there's a little bit of a black hole we've discovered in between the two pieces of the system, and we do our very best to make sure folks are aware that they have to opt into our program in order to be notified. At this point, we're right at about 7,000 people enrolled in our program. In 2017, we did 43,000 plus annual notifications and contacts on behalf of victims of crime. You can see by the number of staff we have in that last bullet point there that we're quite busy. We are on the phone most of the day. We get 500-600 phone calls a month from folks with questions about what their letters actually mean and what they need to do in the process next. So we spend a good portion of our day directing folks through the system and letting them know what exactly is happening. The Victim Rights Act obviously has specified crimes that provide the right for people to enroll and be notified and participate in the system. I think they're very self-explanatory. I don't need to read each of those to you. Another screen here with more of the crimes in the statute. Several of those have been added just over the last few years. A violation of a protection order in a stalking case was added recently, as well as posting a private image for harassment or monetary gain. Another more recent one was the failure to stop at the scene of an accident resulting in death or serious bodily injury. That was added recently as well. The next thing I want to tell you about are the critical stage notifications which we have to provide when someone enrolls in our program. Again, these are all part of the Victim Rights Act. Every time an offender is moved or reassigned to a facility, we notify the victim so they're aware of where the offender is being housed. That does not include day trips or trips out for court proceedings or medical appointments. There's several reasons behind that. It is a move that can happen in a day, and sometimes people would get a notice and the offender's already back in housing, and it's also a security issue. So those two kind of things we do not make notifications on. The next thing that happens in most cases, unless it's a life without parole sentence, we have Community Corrections Board reviews. And I'll talk about that a little bit more, how those dates are calculated and figured as we move along. But this is a stage in the system that we found very, very much of the time people are not aware of, that this can happen as many as 19 months prior to an offender's parole eligibility. This is a halfway house setting in community corrections, and the boards have to approve offenders to be part of their program. So at this stage, victims are provided the right to attend in person and speak at those board reviews, along with providing a written victim impact statement. The offenders are not present for these reviews. They've provided a packet of information and a letter requesting to be part of a community corrections program. You can see some numbers there from 2017. We had 97 people attended 47 board reviews. When you move down to the parole board hearings section, which it seems most people are most familiar with, that being a process in the system, we had 876 people that attended more than 400 hearings. So that's another piece of our obligations, is to coordinate and provide information for people who want to attend and speak to the decision makers in person. Along with the written VIS, one or the other, whatever is the preference of the person wanting to participate, we'll make sure it's all coordinated and handled. We, of course, always notify of all the decisions of those proceedings, and following that would be any release decisions. If an offender is released on early parole, if they're granted that privilege, that's discretionary parole. And since about 1993, when the laws changed, most sentences have a mandatory parole date. And that's all according to how the judge sentences an offender. And at that point, when that date comes around on the calendar, DOC legally has to release that offender to parole, and then they can begin serving their parole period. If they're released early on discretionary parole, that 1, 2, 3 year parole term begins at that point. There is an option partway through a parole sentence that an offender can apply for early discharge from parole. That means their sentence would end if the parole board approved that early discharge. Again, another point in time where people can come and make their statements in person to the board, as well as write a written victim impact statement. Special needs parole, those reviews are again done by the parole board and probably more well known as a compassionate release. Offenders who have a debilitating medical or mental health condition can apply for a special needs parole no matter what their release date is, unless they have a life without parole sentence. A couple years ago, we had a program that was required for the department for juvenile offenders who were convicted as adults. This program is in addition to the resentencing that happened based on some Supreme Court rulings back in 2012 and 14. What it amounts to is a specialized 3-year program that's geared toward this population of offenders. And if they successfully complete that program, they can be presented to the parole board. Again, another point in time where attendance and in-person statements are allowed along with written statements. The difference with this parole board release would be that the board makes a recommendation to the governor, and the governor is actually the only one who can approve a release for this population of offenders. This last page of critical stages include, of course, escapes from secure prison facilities, and that's also walk away from a community corrections program. Abscond is a status of an offender who is serving their parole term and their whereabouts are unknown. So when we issue a warrant for their arrest, we also notify anyone enrolled in the program. The subsequent apprehensions of those offenders is also a stage of notification. We send advance notices out a few months ahead of time when an offender is getting ready to discharge their sentence, which means they'll no longer be under any supervision by the Department of Corrections. Clemency is another stage which includes a commutation of sentences for offenders serving time, and it also includes pardon, and that would be for offenders who have discharged their sentence years ago. Death, we notify upon if the offender dies while in the custody of DOC, and of course execution is the last critical stage listed. Fortunately, I have the discretion to enroll more than just victims and survivors who meet the statutory criteria outlined in the VRA. It's a case-by-case basis that I review those, and very often it's for law enforcement officers, sometimes attorneys. I even have judges enrolled in our program who may have been threatened by an offender. Perhaps an individual who has a protection order from a case that has been adjudicated and the offender's no longer serving time for, but they have a very vested interest in how the sentence progresses. The difference in this type of enrollment is that we cannot schedule people to come and speak at community corrections reviews or parole board hearings. The requirement there is that the person coming to make a statement is the victim of the offender's current incarceration. So there is a little bit of a difference there in what we can allow to be scheduled. But anybody can submit a written impact statement to be provided to the board, and we'll be glad to provide those on anyone's behalf who is not able to go and speak at a hearing. Restitution is a topic that we get asked a lot of questions about, and in general, I can tell you that statute provides DOC the right to retain 20% of any funds that are deposited into an offender's account. If the offender is also responsible for a court-ordered child support, that number will be divided in half. So 10% would be for restitution and 10% would be for child support. And this is a function that the Victim Services Unit does not oversee or have access to. It all happens through our business office. So we're glad to share phone numbers for that if anyone has questions about restitution. And many times offenders leave DOC without having paid their restitution. And if that's the case, we have to refer those balances to county collections when the offender is discharging their sentence. Unfortunately, there's no punitive measures to be taken if restitution isn't paid. So that's one of the things we do get a lot of questions about. Another thing we get quite a lot of requests for is contact between victim and offender. And this happens very often with family members who are victims and would like to have mail, phone, and visiting privileges, which are all baseline prohibited by DOC policy. And again, it's a case-by-case review and exception to look at that, which is the responsibility of the warden at the facility or a manager in parole. Oftentimes, there are protection orders that are modified or even dropped. However, that's not a guarantee that contact will be approved. So it's a case-by-case decision basis, and we actually do a lot of reviews for those requests. Every week I'm looking at those for the wardens to make a recommendation. Another piece of our services that we can provide, we have a staff member who works with the Sex Offender Treatment and Monitoring Program. And this position serves to help people understand what sex offender treatment looks like in prison, and if an offender is participating and progressing through the program. The liaison doesn't provide professional counseling sessions for victims, but they're an information resource, and they can also participate with folks in parole board hearings if they'd like to know more and have someone with them in that regard for those particular crimes. Something I always like to try to explain is the difference between good time and earned time. And I know a lot of times they're used interchangeably, and they're actually very, very different. So I'm going to take a few minutes here to describe what each of those are, and hopefully this will help in understanding how sentence calculations work, because I think it's a mystery in most cases. A 10-year sentence in prison does not mean 10 years in a prison facility. So a 10-year sentence, I should rephrase that, a 10-year sentence does not mean 10 years in prison. And I think this will help make a little bit more sense out of that. The good time referred to out of statute is something that happens as soon as an offender's minimus, their sentencing document, comes to the DOC from the courts. So most of the time, it's 50% of their sentence, and I'll talk more about that. This is the time frame that's used to determine parole eligibility. So that'll make more sense here in just a minute. This is a piece that can be forfeited if an offender gets a code of penal discipline sanction. It is not vested and it can be taken away. The only offenders this doesn't apply to, aside from life without parole sentences, would be offenders who have an indeterminate sentence for a sex offense. So to give you a visual of how this looks, if that's a 10-year sentence in blue, the good time or sentence reduction at 50% determines when an offender is eligible for parole. And in most cases, that's going to be 50% of their sentence. This next slide describes the crimes that reduction is only 25%. So they have a 75% time frame before they're eligible for parole. And as you can see by the numbers, that's only 6% approximately of the admissions to DOC. So 94–95% of the cases that come into the department are going to have a 50% reduction. These crimes listed specifically in statute are the only time that we can use that 25% reduction rather than 50%. If it's one of these crimes that's an attempt, a conspiracy, solicitation, or accessory, it defaults back to the 50% for the parole eligibility date calculation. Earn time. Completely different set of award for offenders coming into the department. This is time that is awarded on a monthly basis and deducted from their sentence. So for them to receive that earned time, they have to be program compliant and write-up free. And once that's awarded, it cannot be taken away. We can withhold it if there's a policy violation or a code of penal discipline violation, but we can't take it away once it's been awarded. In totality, it can't exceed 30% of the offender's sentence. Typically, it amounts to 10 to 12 days each month. So when you stop and think about 50% of a sentence coming off with good time, and then 10 to 12 days each month, that moves that parole eligibility date closer in time. And that can come about pretty quickly. In fact, there's many times offenders with 50% good time, earned time, and that time frame for community corrections can be out in the community again in 33 to 35% of their sentence. This slide shows you some different types of earned time, and I can tell you that this statute has been modified and added to multiple times over the years, and all of these different types of earned time can be awarded in addition to that 10 to 12 days per month. So there's always another opportunity for those dates to change, and that's one reason that enrollment in our program is so important. If people want to know when an offender may be released, we can help guesstimate that for people. It is most often very much sooner than people expect. This slide describes the crimes that can be statutorily considered a crime of violence. There's obviously a lot of other crimes that are violent and offenders that are convicted of crimes that are not in this list. And this is something that very often is misunderstood, that automatically provides for 75% of their sentence being served. And we have to see that statutory reference on an offender's sentencing document, the minimus, in order for it to be considered a crime of violence. Very often, I think, our logical assumption is that a crime is violent, and it may very well have been, but if it's not outlined in this particular statute and on the sentencing document, it is not considered a crime of violence. And where that comes into play is with those community corrections referrals. These offenders are not eligible to be referred for community corrections at 19 months. They can be at 9 months. So that's basically the difference in where we see the crime of violence come into play when an offender is looking at release opportunities. So I'm going to switch gears completely here and talk about some victim-centered practices in DOC. I think I've told you enough about all the benefits of the sentencing and release opportunities for the offenders. So I want to share some things that have been implemented that are victim-centered. Some years ago, I started an offender apology or accountability letter bank, and I wrote some guidelines for the offenders who are interested in doing that. And I actually have about 400 in the apology letter bank right now. And I review them all. If they're not appropriate, they don't make the cut to be placed in the bank. This is one of those opportunities that a victim can reach out to us and see if there is one, if they're interested. We don't automatically send those out. It may be something that is very unwanted and not well received, and we absolutely appreciate that. So folks enrolled in the program, if they read our newsletters and flyers and things that come out in our mailings, they know that this exists and just need to call our office if they're interested to see if their case is one of the apology letter bank files. So another thing we do working with the Crime Victim Advisory Council out of the Denver DA's office is we have victim impact panel presentations. We have folks that have been victims of violent crime who will come into the prison facilities or halfway houses and share their stories about how violent crime has impacted their life. And I've witnessed a lot of these presentations, and I can tell you that there actually are some offenders who really appreciate hearing this, and it is kind of like seeing light bulbs come on where they finally realize some of the trauma that they've caused. Even if it's not exactly the same kind of crime that they were involved in or sentenced for, it's an opportunity for them to be exposed to what violent crime does to people and the ripple effect that comes from that. So it's actually been very, very beneficial to the folks who come in and do it too. I think it makes a difference in their life that they hope that they can prevent one more victim from being harmed. Victim offender education groups. This is a program that originated in California in San Quentin. And the director of that program is now here in Colorado. And we have started doing some programs at 4 facilities at this point, bringing offenders in small groups and educating them on what they've left behind with people in the community and their families and those that they've harmed. It's gotten some amazing feedback. Offenders are telling us that this has taught them more than any other class they've taken in the Department of Corrections. So I think that speaks volumes. The last thing I want to tell you about is our Victim Offender Dialogue program. And I'll say this over and over again, this is not for everyone. And I understand and absolutely appreciate that. In the cases where we've been approached by victims and survivors who want to speak to the offender in the crime, when they want and need that opportunity, it is a very beneficial program. But I'll explain a little bit more about that, and I'll probably say it several times, that this is not for everybody and not for every case. The program is based on some very solid foundation. A dialogue does not happen unless it's initiated by a victim or a survivor. The whole process is victim-centered. We have trained facilitators who've spent weeks training specifically just to facilitate these conversations. It's always confidential. It's volunteer. If anyone wants to stop the process along the way at any time, we will absolutely do that. And we ensure that it's safe. If I have any doubts about anyone's safety, then the dialogues don't happen. I can tell you that the program is not intended to benefit the offender's release or any status that they have in prison. And they actually sign an agreement acknowledging that. It's not meant to get them an early parole or get their sentence commuted. So they have to come into it with the right intentions, and with the desire to serve the victim, answering questions and providing information no one else can, for me to approve the program for them. Dialogue is not therapy. The facilitators are not trained therapists. That's not the intention of it. I have seen very therapeutic results from the dialogue, but that's not the main intention. And forgiveness is definitely not a prerequisite, a requirement, and it's not focused on forgiveness. Sometimes that happens, but every case is different. And another distinction I like to make is that it's not mediation. We're not trying to come to any sort of agreement. We're there for the victim survivor to have questions answered and to be able to voice their experience directly to the perpetrator of the crime. There it is again. BOD is not for everyone or for every case, but I do like to make folks aware of the program because I'm sure people don't know that this is an option for them. And if it is something they've thought about, they can certainly call my office and I'll be glad to talk more about it with them. I want to share a short video with you. It's just about 4 minutes long. And this is focused on several people who have actually been through the process and wanted to share their experience and how they benefited, from going through the dialogue program. We're going to go back a slide here. Excuse me for that.
I had really done a lot of self-care, really embracing my grief process. I just felt like that something else was missing. I heard about this restorative justice dialogue thing, and I'm going to give that a try.
The Victim Offender Dialogue Program is a very rare opportunity in the criminal justice system. It's a rare opportunity for the victim's voice to be heard directly.
It's a way to get more information, a more complete story, so to speak, get some answers.
It's victim-centered at its core. It's always victim-initiated, and it's always voluntary.
I wanted to do the dialogue because I wanted a release. It was something that I needed to do for me. I needed the questions answered.
We definitely wanted to make sure he was held accountable for what he had done, make sure that he was remorseful for what he had done.
I wanted to hear the authenticity in their voice. I wanted to hear that they were truly remorseful, just to see his face and to know that he was feeling, the pain that I went through. I wanted him to know how he had changed my life. I wanted him to understand, to see, to look into my eyes, and to know the pain that he had caused me by his decision and by killing my son. The preparation for the dialogue was actually pretty awesome.
We identify what the key needs are. Is it a bit of information that a survivor may need? Is it an opportunity to express their anger or their sadness?
So I had a lot of anxiety. But at the same time, I had a lot of anticipation and excitement because I had wanted this.
The outcome was more than I expected.
The end result is, in many ways, freedom, the ability to loosen some of the burdens associated with being a victim. The thing that stands out most to me from the dialogue is the sense of peace. We walked in there without it, and you walk out with a sense of, okay, I finally know. I heard his remorse. I heard him take accountability. And now I can put it back on him.
what I took from the dialogue was peace. That dialogue filled the gap of uncertainty, questions that I had that throughout those years of waiting to have the dialogue, they were all answered.
When we went in, we did a deep breath because we were so nervous. When we went out, we were able to actually take a breath, and it felt so good. And we were able to just let it out, and it was awesome.
Doing the dialogue brought back my voice to me. I felt when I walked out of that prison that I was in control.
We needed to go through this to move forward.
I, from that moment on, was a survivor. I was no longer just a victim.
There's some information on this slide for you in regards to contacting COVA, or again, I will provide more information on that if anyone reaches out to us at DOC directly. This slide gives you my direct email and my direct phone number. If you have questions, you're more than welcome to call or email anytime. Jen, do we have any questions in the queue there?
Yeah, there were a couple questions that came up, and I apologize, that video was a little choppy, so I'll send out the direct link to that video with the follow-up as well. That was an issue with our connection here, I think. So we have a couple questions here. The first one is, who speaks to the offender to vet them for a VOD?
Actually, that's me. I field every request that comes in from a victim or survivor after I've spoken with them to see what their intent is and see if it's an offender who meets the criteria to be part of the program. What I will do is go directly to the prison or the parole office and direct the question face-to-face to the offender if this is something they would be interested in participating in. And the reason I do that is because that face-to-face reaction is very telltale for me, and it gives me an opportunity to gauge how they feel about this as an opportunity for them to do the right thing. And out of the 13, 14 cases that we have facilitated so far, it's proven to be very beneficial for me to do that in person. So if I'm unavailable, I think 1 or 2 times I've had a specialized facilitator do that on my behalf. And so we vet it very, very closely, and I'm very particular about how this proceeds, because the last thing I want to do is cause someone any more harm. And if the offender's not right for the program, we just don't want to put that person in a room and try to make it work. It has to be right for this to be healing and beneficial. So it's done face-to-face and personally.
Thank you. The next question, I think you may have answered. How many VOD cases have been done in DOC?
We have one, I believe our 14th one is happening next week. I have 2 that are in preparation phase right now. And the goal is really quality over quantity. And of course, it has to be victim initiated. So as they come to us, we look at those and review them, and there's been several cases that haven't worked out well for some reason, but we work through that with people and see if there's any alternative things that we can do for them. So again, it's number 14 coming up here next week.
And are there crimes that are excluded that you absolutely would not do a VOD with?
At this point, we do have some parameters on the types of crimes that we're able to do dialogues for. Those crimes are domestic violence, sexual offenses, stalking offenses. And the reasoning behind that is that's another layer of specialty that we would need staffing for to be able to safely facilitate those dialogues. And my hope is that at some point, the resources will be there for us to do cases with those particular crimes. But at this point, based on resources and everyone's safety in mind and well-being, we are not doing those cases.
And then we have another question about whether children are allowed to visit offenders at DOC. If the child was not a victim or a survivor in the case, can they visit an offender in DOC?
There are some parameters on children visiting in DOC. With sex offenders, there's a baseline that there are no minors allowed to visit. That, again, is a case-by-case discretionary basis that's made by a multidisciplinary team with those cases. Depends on their crime, certainly. If the child or minor is not a victim, typically they are allowed to come in if there's no issues surrounding the type of crime or the nature of the crime. If there are issues, that can be discretionarily reviewed by that multidisciplinary team, and exceptions can be made.
Another question is, if an inmate is going through the appeals process, does that disqualify them from VOD?
Yes and no. If they are appealing the case because they are denying the crime and not taking accountability, that is a significant issue. We would not proceed with the dialogue if the offender doesn't take accountability for the crime. If they have an appeal on some other sort of technical basis, we could consider it, but that would be a discretionary decision that I would do on a case-by-case basis.
Okay. And then it looks like we've got one more. You may or may not be able to answer this one. What is the status of 16-180?
Senate Bill 16180, that is the Juveniles Convicted as Adults program. And at this point, it is still part of the statute, and we have, I believe, 12 or 13 offenders in that program, which is housed at Fremont Correctional Facility. There are approximately 47, 49 offenders, I can't remember exactly, who are in that population of offenders. 13, I believe, is the total number of the offenders in there right now, and we started that program in November of 17.
Okay. Does that answer the question? Okay, so the other piece to that was around an appeal that was filed by DA George Brockler, and it's supposed to be heard in June. Do you have any information about that or know anything specific to that appeal?
You know, as long as the statute is in place, until we get direction otherwise, we will continue the program.
Okay. So it sounds like that is not, where the appeal is not necessarily something that you have information about.
I don't know the specifics about that.
Okay.
So until legislation changes or some directive is given, the program will continue so that we're in compliance with statute.
Okay, thank you. Are there any other questions? You all have just a perfect understanding of good time versus earned time and all of that stuff now? Yeah, me too.
It's pretty confusing, and every case is different. People are certainly welcome to call our office if they want to look at a particular case, and we'll guide them through what it looks like at this point and what it may look like in the future. It is a very confusing system. I've been working in the Department of Corrections for 21 years, and I still have questions every day. So being thrown into the system without any idea, I completely understand the confusion, and we're there to try to clarify some of those things.
Great, and we appreciate it. And I can definitely say that as, you know, busy as their office is, I know that Monica is always really quick to respond, and so if you have questions, definitely reach out for those kinds of specifics. It looks like one more question did come in here. Okay, this one is regarding community corrections reviews. So are the cases that go before the Community Corrections Review Board that you are involved in only those coming out of prison, or are they some of those that are avoiding prison? So,
okay, with community corrections, there's two different populations of offenders that reside in halfway houses. The direct sentences are the ones that judges sentence directly to community corrections, and those offenders are not under the purview of the Department of Corrections. The offenders we have custody of and purview over are the ones transitioning from prison. So those are referred to as transition clients, and those are the ones that still have a DOC number. If they were sentenced directly to community corrections, they don't have a DOC number. So our victim services unit provides notification for victims regarding offenders who have a DOC number. So whether they're in a prison facility, in a transition bed in community corrections, or on parole, those offenders are DOC. If they were sentenced as a direct community corrections, or if they're on probation, those are not part of the Department of Corrections.
so if someone were looking for notifications related to someone who was sentenced directly to a community corrections facility, what entity would they need to contact to get that information?
There are some halfway houses that do notification directly. Some are through probation. And so what I typically do is refer that individual back to that judicial district, because there's 22 districts in the state, and depending on where that halfway house is where they would receive those services for notification when it's not a DOC offender.
Perfect. Okay. Does that answer the questions that have come through so far? Yes. It's like that was the follow-up question. Great. Any other questions before we wrap up here? I did want to just take a minute to talk a little bit about the information that was on the screen at the end of that video. So COVA is currently working in partnership with the University of Denver on a research study related to how VODs, victim offender dialogues, impact victims. A lot of the historical research around VODs has really been focused kind of on how they impact offenders. And so this is one of the really first large-scale studies that's looking at those impacts on victims. So if you're interested in more information about that study, or you're working with someone who you think might be interested in being involved, you can get in touch with us here at COVA, go to our website, and there's more information there as well. And as part of that, we have 5 trainings that are going to be coming up regionally over the next several months that are not necessarily specific to VODs, but are more just broad information about restorative justice, and are really designed to encourage collaboration between victim advocates and the restorative justice community. So I think the first one of those is coming up in June. Yes, so that starts tomorrow. June does. I think it's June 20th. And I don't recall offhand where that one is going to be, but you can also find information on our website, on the VOD page under programs, or on our training calendar about when those are coming up. And you will probably, if you're on our email list, you'll get some additional information about those coming through email in the future. So I did want to just make sure that I mentioned that.
Jen, can I interject that research study is not just for DOC offenders, it's a multi-agency collaboration. So if an offender is on probation or is a direct sentence offender to community corrections and it was a crime of violence, or there's a long list of them actually, but those offenders are also included through probation and the Division of Youth Services. So it's not just offenders sentenced to the Department of Corrections for folks who are interested in a dialogue.
That's great to know. So if you all are even working with folks who have an offender who is on probation, then that might be an option for them as well, if they are interested. And as Monica explained, it's a very victim-centered process, And there's lots and lots of preparation that happens before the actual dialogue occurs. Any last questions before we wrap up and let you all get on with your day? Okay, I'm not seeing any at the moment. Again, if you have questions, feel free to contact me. I'm Jen at COVA. You've probably gotten some emails from me already, or you can contact Monica directly. And this will be recorded, so I will be sending out a follow-up email to you all. That email is also going to serve as your certificate, if you will, of attendance. So within that email, it will document how long it was and the date of this. So you should get that by the end of next week, and I'll include a link to the webinar recording as well as a direct link to that video that Monica showed as part of this webinar, and the handouts as well. So please, there are other folks that couldn't attend the webinar today who you think would be interested in seeing this. You're welcome to share that link with them.
Thank you all so much for your time. I really appreciate your interest and hope the information was helpful.
Yeah, and thank you, Monica, for being here with us today.
Thank you for having me.
Appreciate it. Okay, we're going to sign off. So have a great rest of your day.